The courtroom was tense long before the hearing officially began. Reporters lined the benches like watchful hawks, pens poised, cameras waiting for movement. What had been scheduled as a procedural hearing was now drawing national attention because two women known for their sharp intellect and iron-clad resolve were about to clash. On one side sat Judge Tanya Chutkan, composed and stone-still, her gaze scanning the courtroom with the trained neutrality of someone who had long ago learned to conceal every flicker of emotion. On the other side, taking her seat at the presentation table, was Congresswoman Jasmine Crockett, stepping in as a legal advocate for a transparency petition, challenging perceived inconsistencies in judicial oversight. It was an unusual, even historic dynamic. An elected lawmaker and a federal judge facing each other not across branches of government, but across the very terrain of the law itself. As the clerk called the court to order, Crockett rose with a calm, practiced confidence. She adjusted a stack of organized documents, though she hardly needed them. It was clear she had rehearsed every line, every angle. Her voice, when she spoke, carried cleanly through the courtroom. "Your Honor," she began, "I stand before this court to address a concern regarding potential bias in the administration of prior rulings, not accusations. Concerns rooted in patterns visible in the public record." A ripple of whispers moved through the gallery. It was not common to hear a judge's impartiality questioned to her face. Not with such directness, not in such a formal setting. Judge Chutkan didn't flinch. "Ms. Crockett," she replied evenly, "this court will only entertain arguments grounded in law and fact. You are welcome to proceed, but you will maintain decorum. If your intention is to imply misconduct, you must do so through proper legal channels." Her tone was calm, but beneath that calmness was unmistakable warning. Crockett nodded slightly, accepting the boundary, but not retreating from her purpose. "Of course, Your Honor, my intention is clarity, not conflict." She walked closer to the lectern, placing her hands on either side of it. Her posture was straight, unburdened by hesitation. "I would like to address a sequence of rulings issued under your supervision, particularly those involving prosecutorial discretion and pretrial limitations. These rulings, Your Honor, show a pattern that has resulted in substantially different treatment of similarly situated individuals." The judge folded her hands. "And your evidence?" Crockett flipped to the first tab in her binder and lifted several pages. "Documented case summaries from the last 4 terms, supported by both court transcripts and publicly available judicial orders. I'm not here to allege intentional bias, but patterns matter, and transparency demands that patterns be acknowledged and explained." Judge Chutkan's eyes sharpened not with anger, but with a piercing attentiveness. She had been on the bench long enough to recognize when a tactical framework was being constructed. Crockett wasn't improvising. She was building toward something. "You may submit the summaries," the judge said. "But this court will not entertain conjecture. Patterns alone do not prove bias." Crockett stepped forward. "No, Your Honor, they don't, but they do justify inquiry." That line landed like a stone. Judge Chutkan leaned slightly forward. "Ms. Crockett, this is a courtroom, not a congressional hearing. You will follow the standards of evidence and the constraints of proper legal argument. I will not allow this proceeding to become a platform for political theater." The Congresswoman's expression remained neutral, but the courtroom felt her energy shift, measured, deliberate, unshaken. "Your Honor, with all respect, my role here is not political. It is legal, and even the appearance of bias, whether intended or not, falls under the purview of judicial accountability." A flicker of irritation passed through the gallery, not from the judge but from the spectators. Some admired Crockett's boldness. Others saw it as provocation. But the judge herself stayed still. "Ms. Crockett," Judge Chutkan said, "I will not allow insinuation to be disguised as legal inquiry. If you have evidence of misconduct, present it. Otherwise, move on. Crockett took a slow breath, as if deciding how far she could push the threshold without stepping over the line. It is active and courageous. Let's move to specifics. She flipped to another section of her binder. Case 14B27, Case 17C02, Case 19F12. In each of these cases, Your Honor imposed preemptive limitations on defense access to certain records, yet in 6 comparable cases prosecuted under different jurisdictions, those limitations were not imposed. My only question, relates to consistency. Judge Chutkan's tone shifted, becoming firmer. Consistency, Ms. Crockett, is a matter of legal context. No 2 cases are identical. Crockett leaned forward slightly. True, Your Honor, but the law demands not only justice. It demands the appearance of justice. Judge Chutkan's patience thinned by a fraction. Only a fraction. Ms. Crockett, I will stop you there. You are bordering on questioning the impartiality of this court without basis. You may address legal rulings, but you may not imply bias. Crockett met her gaze without blinking. I'm addressing outcomes, not motives. And outcomes, the judge countered, are determined by law, not by public perception. The air in the room tightened. This was becoming a battle of precision, each woman choosing her words like pieces on a chessboard, both aware that one misstep could compromise their credibility. Crockett exhaled. Then let me reframe. If the court maintains that all prior rulings were applied impartially, I will ask for a written explanation of the legal basis differentiating these cases. An explanation suitable for public review. Judge Chutkan's eyes narrowed. You are requesting that I justify rulings already supported by judicial opinion. I'm requesting clarity, Crockett said. What you are requesting, the judge replied, is unnecessary unless you intend to accuse this court of wrongdoing. The room froze. For the first time, Crockett hesitated, not from uncertainty but from calculation. She knew the judge was requiring her to commit to a position. She also knew that overcommitting could undermine her entire argument. I intend, Crockett said slowly, to ensure that justice is both done and seen to be done. If that requires expanded explanation, then that is what I request. Judge Chutkan drew a long, steady breath. Request denied. The abruptness of those 2 words sent an almost physical shock through the courtroom. Crockett blinked, momentarily thrown off balance, but only momentarily. Your Honor, on what grounds? On the grounds, the judge answered firmly, that this proceeding will not be allowed to devolve into a referendum on this court's integrity. You may argue law, you may argue fact, but you will not question this court's impartiality. And there it was, the first clear shutdown. Crockett stood silent for a moment, hands resting stiffly on the lectern. Then she nodded once, slow and deliberate. Very well, Your Honor, then I'll redirect. But her eyes made one thing unmistakably clear. The shutdown was temporary. She wasn't finished, not even close. The pause between Jasmine Crockett's redirection and her next move seemed to stretch longer than the courtroom clock allowed. She stood still at the lectern, flipping through her binder with methodical precision. Judge Chutkan waited, posture controlled, anticipating Crockett's next route with the unspoken authority of someone who had already drawn clear boundaries. But boundaries, Crockett understood, were not walls. They were challenges. She lifted her eyes again. Your Honor, she began, since the court will not provide additional justification for past rulings, I'll confine myself to procedural concerns within today's petition. Judge Chutkan nodded once. Proceed. Crockett drew her attention to a single page, one highlighted, tabbed, and underlined. Today's matter concerns access to procedural review for parties seeking equal treatment in pretrial conditions. We are requesting authorization for an independent evaluation panel to review comparative sentencing and pretrial disparities. Judge Chutkan took only a moment before responding. Denied. A panel would serve no legal purpose. This court is fully capable of evaluating its own procedures. The denial came like a perfectly placed brick, shutting a door before it could fully open. Crockett looked up, the slightest tightening of her jaw acknowledging the hit. But she did not retreat. Respectfully, Your Honor, she said, self-evaluation lacks objectivity. That is precisely why oversight exists in every branch: Congress, the executive, and the judiciary. You are not in Congress right now, Chutkan replied, her tone sharpening. You are in a federal courtroom, subject to the rules of this court. And those rules, Crockett countered, permit me to request review mechanisms that support fair and equal access. Judge Chutkan leaned forward, review mechanisms that are supported by law, not by political apprehension. There it was again, the reminder that Crockett had walked into the judge's domain, not the other way around. Still, the Congresswoman held her ground. She took a breath, steadying her cadence. Very well. If the court denies the panel, then I move to call attention to the administrative discrepancies affecting pretrial restrictions. These inconsistencies create barriers that disproportionately affect specific litigants. Denied. The judge said again, cutting her off before she could continue. Crockett blinked. Your Honor, with all due respect, you cannot issue a denial before the motion is fully stated. Judge Chutkan's eyes fixed on hers. I can deny motions that fall outside the scope of this hearing. You were warned to confine your arguments to relevant legal grounds. You have not done so. The gallery murmured, some in surprise, others in anticipation. Crockett's expression hardened, not with anger but with renewed resolve. She adjusted the microphone slightly, her voice calm but undeniably firmer. Your Honor, if the court's intent is to prevent me from raising legitimate procedural concerns, then I need clarity on what this court considers relevant. Judge Chutkan answered without hesitation. Relevant arguments are those directly tied to the petition before this court. This petition does not authorize you to question the court's impartiality under the guise of procedural review. Crockett exhaled through her nose, a slow, controlled breath that only those studying her closely would recognize as a sign of frustration. So the court acknowledges procedural disparities exist, yet refuses to discuss them. The court acknowledges no such thing, Chutkan said sharply. Do not put words in this court's mouth. Crockett raised her hands, palms outward, in a gesture of contained restraint. I'm restating the issue. Disparities are documented in the public record. They are real. And if this court refuses a panel review or a supplemental explanation, then those disparities remain unaddressed. Judge Chutkan's reply came ice cold. You are attempting to litigate issues that are not before this court. This is your final warning. For the first time, Crockett hesitated, calculating whether pushing harder now would risk undermining the entire case. Her instincts told her to advance carefully, but her conviction told her to refuse silence. The room watched every muscle in her posture as she chose her next strike. She settled on something measured. In that case, she said, let me shift. Legislative intent. The petition arises from concerns that judicial discretion in pretrial restrictions has grown inconsistent with the principles of transparency and public confidence. Addressing these concerns requires at minimum the court's acknowledgement that transparency has value. Judge Chutkan's face remained unreadable. Transparency has value. But it must never become a tool for discrediting the judiciary without evidence. Crockett nodded slowly. Then let me present evidence. That statement snapped the room to full attention. Even Judge Chutkan raised an eyebrow, intrigued. Crockett pulled a single sheet from her binder, a compilation of timelines, dates, and procedural orders. This document shows multiple cases in which pretrial restrictions were escalated without a clear legal trigger. Not accusations, just patterns. And these patterns expose a need for further review. The court will accept the document, Chutkan said, but I caution you not to draw unsupported conclusions. I intend, Crockett replied, to draw necessary conclusions. Judge Chutkan tapped her pen once on the bench, a subtle signal the court staff knew well, an early indicator of impatience. Ms. Crockett, you are now bordering on improper argument. Crockett held up the document. No, Your Honor. I'm presenting an empirical record. If the conclusions make you uncomfortable, perhaps that discomfort is evidence enough that the scrutiny is warranted. Gasps erupted from the gallery. Judge Chutkan's expression froze into a mask of stern authority. Ms. Crockett, she said, each word clipped with judicial force, you will not insinuate impropriety in this courtroom. Crockett refused to break eye contact, then provide clarity that dispels the appearance of impropriety. Enough. Chutkan's voice cut through the tension like a blade. This hearing is not a tribunal against this court. A long silence followed. Crockett lowered the paper slowly. Then how do we address public concerns if not through open dialogue? Through the proper legal channels, Chutkan answered, not through theatrical confrontation. Crockett's voice softened, but her conviction sharpened. Seeking fairness is not theater, Your Honor, and undermining judicial authority under the guise of fairness, Chutkan replied, is unacceptable. Crockett closed her binder, signaling that she had made her point, even if the judge refused to accept it. Then I will enter all supporting documents into the record, she said. Judge Chutkan nodded curtly. They will be reviewed, but you will proceed within the limits of this hearing. The Congresswoman stepped back, her expression composed but unmistakably steeled. She had been shut down over and over, but she had also planted the seeds of doubt, the seeds of inquiry, and the seeds of public scrutiny. The battle wasn't over. It was only shifting. And as the courtroom shifted with it, everyone knew the next phase would be even more intense. The atmosphere inside the courtroom felt heavier now, as though the air itself sensed that the final stretch of the hearing would determine much more than a procedural petition. Jasmine Crockett stood near the lectern again, binder closed but posture resolute. Judge Tanya Chutkan watched her with the unwavering steadiness of someone who had spent a lifetime balancing justice, authority, and public scrutiny. Ms. Crockett, Judge Chutkan said, breaking the silence, you may proceed with the remaining legal basis for your petition. Stay within the confines of the original filing. Crockett nodded, though her jaw tightened a fraction. Understood, Your Honor. She took a moment to gather her thoughts. Gone was the confrontational tone of earlier exchanges. Instead, she adopted a measured cadence, firm, clear, and undeniably strategic. The petition before this court, she began, argues for procedural reform aimed at promoting consistent application of pretrial conditions. The request is grounded in statutory language, permitting courts to establish transparency measures that do not conflict with judicial independence. Judge Chutkan narrowed her eyes slightly. You may explain your statutory interpretation, but refrain from referencing unrelated cases or insinuating bias. Crockett accepted the constraint with a nod. Very well. The argument rests on 3 points: legislative intent, constitutional balance, and procedural clarity. The room leaned in. First, Crockett continued, legislative intent. Congress enacted provisions supporting transparency in judicial administration because public trust is an essential component of lawful authority. When procedures appear inconsistent, even without explicit misconduct, the public's confidence erodes. My petition merely asks that this court consider supplementing its procedures with accessible clarifications. Judge Chutkan responded swiftly. This court does not craft policy based on public perception. We apply law. Crockett countered without raising her voice. Law is applied within a public system, Your Honor, and it must be understood to be respected. A few heads in the gallery nodded. They recognized the line not as a challenge but as an unavoidable truth. Chutkan remained unmoved. Proceed. Second point. Crockett said constitutional balance. While the judicial branch maintains independence, transparency is not a threat to that independence. It strengthens it. A judiciary that acknowledges public visibility becomes more resilient, not more vulnerable. Chutkan's reply was immediate. Ms. Crockett, you speak as though this court resists transparency. Our rulings are public, our opinions are published, hearings are on the record. Your argument presumes a deficiency that does not exist. Crockett inhaled slowly. Your Honor, I'm speaking of clarity, not deficiency. Published opinions can still leave procedural nuances opaque to most citizens. Supplemental explanations, limited in scope, not altering the ruling, would support the public's understanding without infringing on the judiciary's autonomy. Judge Chutkan paused longer this time, not because she agreed, but because Crockett's narrower framing was undeniably lawful. Continue, the judge said. Crockett moved to her final point. Third, procedural clarity. My petition seeks authorization for this court to issue, in select instances, brief procedural statements explaining deviations from standard pretrial conditions. Not just rulings, procedural reasoning, not every case, only those in which the deviation is significant enough to cause confusion or concern. The judge lifted her chin. You are asking me to create additional burdens on this court's docket, burdens that are unnecessary unless you are implying wrongdoing. Crockett shook her head. I'm asking the court to adopt a mechanism, not an accusation. Judge Chutkan tapped her pen lightly. And you are basing the need for this mechanism on your perception, not on legal requirement. No, Your Honor, Crockett replied. I'm basing it on documented patterns, patterns that justify increased clarity, not allegations, not conclusions, simply clarity. The judge closed the file resting in front of her. A subtle signal. She was preparing to deliver a ruling. Crockett sensed it immediately. Before the court rules, she pressed gently, I request permission to make a brief concluding statement. The judge considered the request. The courtroom seemed to collectively hold its breath. You may proceed, Chutkan said at last, but you will remain concise. Crockett stepped forward slightly, folding her hands in front of her. Her voice softened, but the conviction within it sharpened. Your Honor, my intent has never been to challenge your integrity or undermine the authority of this court. I respect the judiciary and the burden it carries, but I also represent citizens whose trust in legal processes is not guaranteed trust that must be earned, protected, and reaffirmed. She paused, letting the weight of those words settle. I bring this petition because transparency is not a critique. It is an investment in judicial strength. In an era where misinformation thrives, more information, not less, is the most effective safeguard for both the public and the judiciary. Judge Chutkan listened without expression. Crockett continued, If this court denies the petition, I will accept that decision. But I urge the court to recognize that procedural clarity is not an adversarial request. It is a public service. She stepped back slowly. Thank you, Your Honor. For a long moment, silence filled the room, thick and unmoving. Then Judge Chutkan straightened in her chair. This court, she began, her tone fully judicial now, has reviewed the petition and the arguments presented today. Crockett's hands rested against the table, steady but tense. The request for an independent review panel is denied. Chutkan stated, Such a panel has no legal basis within the scope of this proceeding. No surprise there, but the firmness of the language was unmistakable. The request for procedural statements supplementing judicial rulings, Chutkan continued, is also denied at this time. This court maintains that published opinions and records provide sufficient transparency under the law. Crockett's shoulders rose in a shallow breath, absorbing the blow. However, Chutkan added, and the room leaned forward collectively. This court acknowledges the importance of public trust in the justice system. While I will not authorize new requirements, I will consider, on a case-by-case basis, whether supplemental clarification is appropriate within existing judicial discretion. A shift rippled through the gallery. Small, but undeniable, Crockett looked up, meeting the judge's gaze. It wasn't a victory, not even close, but it wasn't a complete defeat either. It was an opening, a recognition, however subtle, that her concerns were not dismissed entirely. Judge Chutkan concluded the proceedings. This matter is hereby resolved. The petition is denied, with noted consideration. Court is adjourned. She struck the gavel once. Crockett closed her binder quietly. No triumph, no anger, just a measured exhale, one that carried the weight of a battle fought with precision, restraint, and unwavering resolve. The hearing was over, but the conversation it ignited had only just begun.